All right, so let's go ahead and get started. Welcome. Thank you so much for joining us today. We're excited to have you all for what we promise to be an informative and informational session. Before we jump into the webinar, let me introduce myself. My name is Mara Newman. I'm the Events and Marketing Coordinator at NECA Victoria. And I have Jamie Phillips here with me. She is the Marketing Communications and Membership Manager for NECA South Australia and Northern Territory. And then presenting today with us, we've got Naveen Raghavan, who is the Workplace Relations Advisor for NECA Victoria, as well as the employment lawyer, for Constructive Legal Solutions. And we have also got Dane Benning here as well, who is the Workplace Relations Advisor for NECA South Australia and Northern Territory. And then last but not least, we've got Luisa Gonzaga, who is the Principal Lawyer of Madgwicks Lawyers with us here today as well. And we are excited to have them here to share their knowledge and insights with us. We are going to start with the presentation aspect, and we're going to end with a Q&A at the end. So if you have questions along the way, just jot those down, save them, and then we'll answer them at the end. I'm going to pass it to Jamie Phillips, and she will kind of cover more of the benefits that you're going to get to with today's webinar.
Thanks, Mara. Welcome everyone to today's webinar. As Mara mentioned, my name's Jamie and I'm the Marketing Communications and Membership Manager for NECA SA and NT. There's definitely some familiar faces, but it's exciting to meet all the new ones too. The main goal of today's webinar is to provide you with a greater understanding of Part 2 of the Closing the Loopholes legislation. As Mara mentioned, we've got questions at the end, so if anything pops up along the way, please note it down. This is the perfect opportunity to get those questions answered that you want to know more about. That is all from me. I'm going to hand over to Naveen.
Wonderful. Thank you. Thank you, Jamie. So we're actually going to start with the right to disconnect. And Dane, over to you.
Thank you, Naveen. Well, good afternoon, everyone. So just wanted to start today off with the right to disconnect. So this is probably what's garnered the most media attention of late as far as the second aspect of the Closing Loopholes legislation is concerned. So this came into effect on the 26th of August this year for all businesses other than small businesses. So this will start to impact small businesses from the 26th of August next year. So what exactly is the right to disconnect? Well, this new provision essentially gives employees the right to refuse to monitor, read, or respond to contact from their employer outside of designated work hours, unless it would be unreasonable to refuse. Now, this applies not just to contact from the employer to the employee, but also from clients, suppliers, also attempting to contact the employee. So there's a few things to be mindful of. Now, important distinction, it doesn't necessarily prohibit an employer from attempting to contact an employee. Rather, it's, the aspects are in terms of what would be reasonable refusal under those circumstances, or is it a reasonable contact? So there are a few different things to consider. So first thing was the nature of the contact. So did you do with an emergency? Is it just, change of roster? Things like that. So that's the circumstances. What's the method of contact? So for example, is it contact via a phone? Is it contact via SMS? The employee's personal circumstances. So for example, do they have personal caring responsibilities? This would, things that play into impacting reasonable refusal. And of course, and this impacts us in particular, which we'll get into more detail in a minute. Excuse me. That's the level of compensation received by the employee for being available. So let's take a moment to step away from that. So that's broadly where we're at in terms of right to disconnect, but how might it impact our industry specifically? So it is the view of NECA that it's likely to have minimal impact on the electrical industry. Now, why is this? Well, because our industry already has provisions that adequately compensate employees for being on standby, or being on call rather. So under both the modern award and most enterprise agreements, electrical workers are compensated specifically through both an available for duty allowance as well as specific callback provisions. So let's give an example there. If an electrician receives a call, say after hours, to attend an incident, they're compensated both for being on standby through available for duty, as well as compensated for overtime. So under these arrangements, these are sort of what Right to Disconnect was specifically designed to address. But as electrical employees are already compensated by this, it's not really going to apply. We already have appropriate compensation structures that allow electrical employees to already essentially be dealt with under those circumstances. So this generally means the Right to Disconnect provisions are not going to specifically impact the electrical industry to a greater extent, not certainly compared with, say, other sectors who don't have the same level of formalised compensation structure that we do. Now, having said all that, it's still crucial to understand that this is now a workplace right, whatever that means. No, I'm kidding there. Employees, still need to trend carefully in terms of choosing to exercise this right. So if you were to take an adverse action against an employee for refusing contact, this would be adverse action against a workplace right. So there's things to be mindful of. There is the potential, obviously, still for costly disputes now or litigation for that reason. And the Fair Work Commission does have the right to hear these. But generally, in all those circumstances, we do think there might be an issue, and that's what we're here for. So in summary, despite the large spotlight on Right to Disconnect, it's unlikely to impact our industry to a greater extent, just because employees are already well compensated, both through availability allowance and through corporate provisions. However, it's essential to stay informed and across these changes. So I hand back over to Naveen.
Thank you, Dane. It'll be interesting to see if any interpretation issues arise in our industry. With reference to the new casual employment definition, it is a little nuanced, but it directly relates to the new mechanism for transitioning from casual employment to permanent employment. The new definition still retains the concept of a casual employee not having a firm advance commitment to continuing and indefinite work. The change now, though, is it requires parties to consider the practical reality of the employment relationship. It's not just the terms, the express terms of any employment contract, actual document you have or arrangement you may have. Simply by calling it casual does not simply make it so. Some of the questions you can ask to help you determine if your existing casual employees meet this new definition. First, are your casual employees working a regular pattern of hours that will match up to either full or part-time employment? Does your company have the capacity or availability for future and continuing work performed by existing casual employees? The example there is you may have hired, let's say, 6 casual employees for a specific project. You may say the project is going to end in 6 months and your company is no longer going to be engaged. That is an example of where such casual employees would not meet the new definition because there is no prospect of them continuing the same amount of work. The last consideration, your casual employees, do you allow them to freely reject offered shifts, offered work, without consequence to either their employment or to your operational requirements? Now, with the new pathway to permanent employment, it's called the employee choice method. Please note, if you employ 15 or more employees, you're still bound by the previous casual conversion obligations until the 26th of February next year. It's a bit confusing, but to refresh everyone's memory, it just means if you have a casual employee, they've been employed with you for at least a year, and in the preceding 6 months of their employment with you, they've worked a series of hours that fits a pattern of part of full-time employment. Then within 21 days of the 1-year anniversary mark, you'll either have to make them an offer to convert to permanent employment, or set out written reasons why you're not going to be making that offer. Now, and it's a bit complicated with the dates and so on, but now employees can formally notify you that they wish to change to permanent employment if they've been employed for 6 months or 12 months if you're a small business, being any business with under 15 employees, and they believe they no longer meet the definition, the new definition of casual employment, you will then have 21 days to respond. And if that response is going to be a refusal, it must be made on fair and reasonable operational grounds. Some examples of what would constitute fair and reasonable operational grounds, it's on screen. The last example, there are substantial changes required, to their terms and conditions. You could be signed on to a union enterprise agreement. Obviously, permanent employees under such an industrial instrument may have a lot more entitlements than an equivalent that simply performs work in reference to the electrical award. That's an example of that. Now, note importantly as well, if you have a casual employee convert to permanent employment using this, back pay entitlements, and again, as I said before, it's a bit confusing because there are many different scenarios in terms of what and when will apply, depending on how many employees you have, when you engage as casual employees, and so on. If you have specific questions, please feel free to reach out to Dana or myself, and we'll be happy to assist. The next thing I'm going to discuss is the change to the definition of being an employee in the first place. And this has direct relevance to independent contractors, what constitutes a valid independent contractor. And the side part to that is, if you get it wrong, making sure you keep away from any sham contracting issues. So this legislation, it overturns quite recent High Court decisions around the definition of employment and aims to revert back to the test of determining whether someone is properly an employee or an independent contractor. Now, these previous court decisions were quite influential because it was a market change from the so-called multifactorial test, which is what it is again now. Basically, any assessment should be confined to the rights and obligations clearly articulated in the contractual arrangement. To keep it short and simple, you have a contractual document, and if it clearly expresses a relationship to be one of being an independent contractor, the court said you shouldn't go beyond that and try and determine what actually happened during the working relationship. Now, though, this is back to the multifactorial test, and it must be determined by assessing the real substance, practical reality, and true nature of the working relationship. What does this mean practically for our members? If you use any independent contractor arrangements, and I know many members do, reassess all existing arrangements and objectively consider if they can continue to be independent contractors, or if you should be thinking about these provisions to make the swap to permanent employment and possibly avoid any issues with sham contracting. Our members would already know there are separate ATO requirements. For example, for superannuation to be paid, they're not saying someone is an employee or an independent contractor, but for superannuation purposes, if you're using an independent contractor primarily for their labor, if they're not able to delegate certain tasks or subcontract out themselves, then they're considered an employee for superannuation purposes. WorkCover has a very similar test. Again, reach out to us if you need any assistance with making that determination. This also won't apply to independent contractors who have so-called met the high income threshold. That threshold as of 1st of July this year is 175,000. Now, I'm going to quickly discuss the changes to sham contracting. Obviously, what is sham contracting? It's misrepresenting an employment relationship as a independent contractor one. There's now a change to the defense where previously employers could argue that they didn't know it should have been an employment relationship. And in so not knowing, they weren't reckless in doing so. It's a bit nuanced, but now employers, if faced with such a charge, let's say, from the Fair Work Ombudsman, you now will have to bear the burden of the onus of proof that you reasonably believe at the relevant time that the person you engaged as independent contractor, you thought that that was the right thing to do. And a fairly common way of running afoul of these provisions is where employers find it more convenient to terminate a permanent employee and almost quite immediately re-engage them as an independent contractor, thinking that there will be more flexibility and so on. That it is something you do have to be careful about. Again, urge you to review all your independent contractor arrangements. If you have contractual documents and it's time for you to have a review and so on, again, you can contact us and we'll be happy to do that service. Now, I'm going to shoot it back to Dane, who will now be discussing the workplace delegates' rights changes.
Thank you, Naveen. So we'll change gears a little bit now. So let's sort of start by understanding, who these workplace delegates are and what exactly they're meant to do. So these workplace delegates will be elected or appointed in accordance with employee association rules, so in accordance with the union rules. The intention of the legislation being that they would be involved in resolving workplace disputes. So engaging in consultation about changes, such as changes to rosters, representing employees during potential, say, disciplinary processes, or negotiating on behalf of employees during enterprise bargaining agreements. So under the new provisions, employers now have several obligations to ensure workplace delegates can perform these duties effectively. So essentially, employers must provide reasonable opportunities to communication. So this is between the delegate and union members. Reasonable access to the workplace and workplace facilities. Now, it's worth bearing in mind with this that you actually have to have the facilities in place. It's not unreasonable to refuse access if you don't have facilities. So this might be something like locked filing cabinet. It's one of the examples, or access to Wi-Fi. That's sort of the intention here. And this is a larger one. Reasonable access to paid time to attend trainings. This would be during work hours attending training. And we'll come back into more specific details on that in a bit. It's important to note what employers must not do under these circumstances now. They can't unreasonably refuse to deal with a workplace delegate. Employers are prohibited from knowingly or recklessly making false or misleading information to a workplace delegate, and they must not hinder or obstruct the workplace delegate in exercising their rights. So getting back to this rights aspect. Now let's turn in particular to the electrical award. So as of the 1st of July of this year, clause 26A was added to the electrical award to specifically address and formalise workplace delegates' rights. So this aligns closely with section 350C under the Fair Work Act and formalises obligations, particularly around access to facilities and representational rights. So specifically within the electrical award, representation. So that again comes down to electrical award formalises workplace delegates have a right to represent employees as matters such as consultation over major workplace changes. So that would be redundancies, things like that. That would be a major workplace change, rosters, hours of work, or any dispute resolution. So again, disciplinary matters if an employee wanted to be represented by the workplace delegate. Communication. So again, this comes down to an ability to communicate, whether it's via Wi-Fi with union members relating to specific matters. Access to facilities. So again, lockable filing cabinet, if that's available. And again, this does depend on the size of the business and the nature of the business, whether it has those facilities available. There's certainly no obligation to go out and expand your office to accommodate a workplace delegate. It's more what the workplace is available and providing reasonable access to the delegate. Paid training. Now, in small business employees, so those with fewer than 15 employees are exempt from this, but a workplace delegate has access to 5 days of paid training in their sort of first year as a delegate, then 1 day per year afterwards. In terms of how many delegates are permitted. It's 1 per every 50 employees. So if in case of most members, most medium-sized members, probably only 1 delegate you're typically likely to be dealing with. Now, having said that, with all these rights, it is still essential to remind the delegate that despite all these rights, there are still responsibilities. So workplace delegates must continue to comply with their duties as employees and follow reasonable policies and procedures of the employer, and ensure that their actions as a delegate do not disrupt their normal work performance. So I'll hold back to Naveen now in terms of other access that unions have under these new changes.
Thank you, Dane. Yes, so going to discuss changes to the right of entry regime. And before I do, I might just very briefly summarize what the right of entry regime is. It's obviously the mechanism that authorizes and also controls the entry to premises by union representatives who are authorized to do so. And how are they authorized to do so? They must have a valid entry permit that's issued by the Fair Work Commission. And in the usual course of things, they must also have a notice of entry document, and that notice must be given at least, in most occasions, 24 hours before they enter the premises. And why are they coming to the premises or on the job site? Their authorization is to investigate suspected non-compliance with either the Fair Work Act or relevant industrial instruments such as an enterprise agreement. And these used to be strictly regulated by the ABCC. Unfortunately, it's been abolished. And just a very quick aside, you must make sure you have people on the ground who are very familiar with these provisions, because you will see a lot of tricks being played by union representatives. A common one is to simply present an expired entry permit. Another trick is for one official to present a completely valid entry permit, and then they decide to bring along 3 others. And usually when they're exercising the right of entry powers, they're usually quite aggressive in so doing. Now, an exemption certificate can be obtained by a union, by entry permit holder at the commission. And basically the new change here is they can do this if they reasonably suspect that one or more of their members are being unpaid. So basically they'll apply to the commission. They'll then attend your site without having given 24 hours notice, obviously. And yeah, they can ask for records. You obviously can't, hinder them. But it can be a stressful situation. And the union's argument is that by doing away with this 24-hour period, it prevents an employer from perhaps manipulating data, destroying records, whatever it may be. The reality is this will allow unions even more control to come in and perhaps misuse the purpose of the investigation. It's very common for them to come in under the guise of suspected underpayments, but when they're actually on your site, they may start noticing this OHS problem and that, and so on. And you don't want to be unnecessarily or even illegally coerced into then providing records to do with something other than the stated purpose. In that regard, NECA and CLS, we are presently running or about to run training sessions. If you have any interest in this, it might be useful for your OHS managers, site supervisors, whatever it may be, you can reach out. Of course, now I'm going to send it back to Dane. He's going to briefly cover up some of the other changes from the closing loopholes legislation that we don't consider as relevant, perhaps. Dane?
Yeah, thanks, Naveen. Yeah, the last few changes we'll discuss in terms of workplace relations aspect are more minor and more likely to impact other industries, but we'll touch on them very briefly. So first one would be intractable bargaining determinations. So this is relevant gives the Fair Work Commission new powers in resolving prolonged bargaining disputes. So if parties have been negotiating for more than 9 months and still cannot reach an agreement, they can apply for a declaration that leads to the Commission stepping in to set terms of an enterprise agreement. Next one is sort of greater regulation of gig workers and road transport workers. So essentially, it's the legislation extending the usual protections typically afforded to employees, such as sort of fair remuneration, bargaining rights, to independent contracts. And this one largely impacts, designed to impact anyway, sort of Uber Eats drivers, things like that, anyone using those sort of app-based services who are currently considered independent contracts. That's largely what this is designed to address. And other power, the Fair Work Commission now has jurisdiction to hear sort of unfair contract disputes. So this would be in terms of an independent contract or whether there's unfair terms. So from August of this year, the Fair Work Commission has had this power to now hear these disputes and can set aside terms if it considers them to be unfair, provided the contractor falls below the high income threshold. And finally, there are also some changes to enterprise agreement making. And these largely impact multi-employer agreements and franchisees in particular. So that's where most of these changes are taking place in terms of negotiation. So less impact for most NECA members, but still something to be aware of.
Wonderful. Now we move on to Louisa, who is a dedicated OHS lawyer and an expert in the field. Louisa, I think, would you be able to share your... I'll stop sharing.
All right. Thank you for having me this afternoon. I'm just going to talk through very quickly around safety and what it means for all of you. So safety is really about mitigating risk. So a lot of people think that an incident has to happen before you breach the law. That is actually not correct. So the law, the safety law, whichever jurisdiction you are in, it's about risk-based, all right? So it's about minimizing and or eliminating risks. So if you fail to do that, the prosecution may issue a prosecution against you, either as a company or as a director for breaching the law. Now, what we're seeing at the moment is that there's been a lot of prosecution around the failure to maintain plant and systems of work, but also failing to provide necessary information training and supervision to your employees. Now, systems of work is not defined in the legislation, but what it means is your policies, procedures, and the like. Okay, so in terms of prosecution, that's what we're seeing as a trend at the moment. Now, most of you will probably engage contractors to do work for you and on your behalf. Your contractors are your deemed employees also, but they could also be what's called other persons, right? So you have duties to your contractors, but only to the extent where you exercise control over their work. So as soon as you direct them and tell them how to do their work, what it means is you've exercised control and therefore you are caught within the provision of the control, and therefore you must provide a safe workplace for them. Now, critical to the law, the safety legislation, is you don't have to do everything that is possible, but what you must do is to only provide a safe workplace so far as reasonably practicable. What that means is effectively it's a risk-based legislation, right? So it's a little bit similar to your risk management. It's about identifying the hazard and determining what reasonable control measures you can implement in order to mitigate risks. And I'm happy to answer questions at the end of the presentation. So that's really what the safety law is about. Now, in order for you to breach the law, the prosecution must prove beyond reasonable doubt, because it's a criminal offense, that you have not eliminated or reduced or minimized risk to health and safety. Okay. Now, how does respect at work have a part in safety law? So I'm just going to talk about the critical changes in the respect at work, and you can have the slides, so I won't go through them. So effectively, the critical changes is that you as an employer now has a positive duty to eliminate discrimination in the workplace. So that is on the grounds of sex discrimination, sexual harassment, and hostile type environment. And that could mean also bullying and harassment in the workplace, okay? Now, victimization is now also a criminal offense if you victimize someone because they've raised safety issues as well, okay? So there is a connection between this law and also safety law. And victimization is actually a criminal offense under the safety legislation. And they will work concurrently when there is an issue in terms of risk of sex discrimination and bullying in the workplace. So everyone knows what bullying is. So it is a conduct that is repeated and unreasonable. So the key here is the repeated conduct, but depending on the conduct, a single event could also constitute bullying. Okay. Now, remembering when I talk about provision of and maintenance of safe workplace, if you fail to eliminate bullying, WorkSafe or regulatory body may also prosecute you under this law. And I'll talk a little bit more about the recent prosecution around this. Bullying can occur through verbal, social, it can be overt, covert, and also cyberbullying is part of that as well. Now, sexual harassment, it is a conduct that is unwelcome, inappropriate physical contact, and the like. Now, what we're seeing at the moment is that there's been a lot of complaints, workplace complaints, in terms of sexual harassment. And I can tell you probably in the last 8 months, we've done probably 5 investigations on sexual harassment. And there's been quite a number of significant fines that have been imposed on employers for failing to eliminate sexual harassment in the workplace. So the Fair Work Commission, they can deal with stop sexual harassment orders, and I'm sure that NECA, through their employment team, can provide you more advice around that. So discrimination, this is a critical one. Really, it's about if someone has a protected attribute, and because of that attribute, you have discriminated a person or a group of people. So that could be because of their sex, gender, sexual orientation, marital status, and the like. Again, there's been quite a number of, we've done a number of investigations arising from discrimination. And again, I defer you to NECA. If you have any issues around this from an employment point of view, then you can contact them. I know I'm going through the slides very quickly because I've got very short amount of time to discuss this. Now, as I mentioned earlier, victimization is now an offense, and under Section 76 of the OHS Act in Victoria, and certainly in other jurisdictions, it is a criminal offense. So what is victimization? So victimization can occur on a number of ways. So if someone has made a complaint and you subsequently victimize them because of that, that is an offense. Again, there is a connection between this and employment, and I defer you to NECA to so that they can provide you advice around that if this becomes an issue for you. So I've just set out what is a protected action and what may constitute victimization. And I'm not going to go through that, but you can have the slides and you can go through that at your own time. How to prevent unreasonable workplace. Early intervention is critical, training, and really creating a safe culture within your workplace, and really identifying the risks around that, ensuring that you have training for your staff, but also refresher training. Now, you may recall I talked earlier that one of the key prosecutions that work safety prosecution at the moment is the failure to provide necessary training. So it's important that you have not just your one-off training, but refresher training. That's critical. And certainly from the prosecution that we've defended, one of the critical things is this aspect, okay? And it's important for you to review your systems of work, because how do you know that they're still effective, and also that they're still responding to the risks arising at your workplace? So they're kind of, you know, all integrated. How to investigate a complaint, but more so generally how to investigate any workplace issue. So it's important to understand that you must have a grievance process or an investigation policy, because without that, it becomes an issue, right? So the level of investigation that you will require to undertake will depend really on the severity of the complaint. So for example, 12 months ago, we have received instructions to investigate 62 allegations of discrimination, harassment, and bullying. So that was an 8-week investigation process, and we had to follow strict terms of reference when we're investigating that. So it's important that you, however small the complaint is, you must treat it with due care and process. And I've provided in the slide what you must do when you receive a complaint. Now, regardless of whether you think the complaint is vexatious, you still have to go through that process. It's very critical. So a number of prosecution outcomes. There has been a number of prosecutions in terms of sexual harassment. Now, just before I talk about this, psychosocial hazard is law now in other jurisdictions. In Victoria, it's still not a set law, but what I can say about that is that psychosocial hazard is a safety risk. So regardless, you must identify, assess, and put control measures in terms of psychosocial hazards, because if you don't, then you may also be prosecuted for failing to mitigate or address that risk. So sexual harassment prosecution, WorkSafe investigated a company in April 2021, and following their investigation, they issued a prosecution against the director and the company for failing to provide and maintain a safe workplace. So because it's a criminal offense, if you're a director, it stays in your record for the rest of your life, I guess. There might be issues around you traveling overseas if, as a director, you've been convicted under the safety law, because it is a criminal offense. Now, the fine for the company was $110,000, and for the director, he was fined $140,000. Now, if you still have insurance that would indemnify you for fines issued by the court. It's now a criminal offense also for you to rely on that insurance. Okay, so you can no longer rely on your insurance to pay for for the fines that the court may issue against a prosecution that's been issued by the regulator. Bullying prosecution. Now, this is not something new. There's been a number of prosecutions around this, but this is just highlighting that it is real, and that if you fail to take action in preventing bullying behavior in your workplace, that there is a risk that a regulator will prosecute a company or its director for failing to mitigate those risks. I know I've gone through that very quickly, but I'm happy to answer questions at the end of this presentation. Thank you.
Awesome. Okay. So that wraps up our presentation aspect. Do we know what happened to Naveen? I think he needs to come back on here just to answer some questions, but if not, Dane can take and Lisa can take questions. So let's see, it looks like we have 2 questions in our Q&A. So if you have questions, please just start popping those in there and we'll go through them and answer as we can. So the first question that I see on here is a question to Louisa. So what are your thoughts on their success of a claim for harassment, intimidation, bullying, and victimization against a union official? Oh, Louisa, you're muted.
Yeah, that's interesting because recently one of our clients had contacted us because a union member had gone in on site and started videoing and filming one of the employers. So we actually had to call the police because obviously they didn't have a workplace rights. And Naveen, I can defer that to you from an employment point of view. But I haven't seen any case, but certainly unions are also employers, and they have a duty to other persons, which is our client in this instance. So they could also be prosecuted for such behavior in terms of intimidation and the like. And you can, in fact, even ask WorkSafe to investigate that if you feel that they have breached the law as well. And I'm sure that would be an exciting time when union officials get prosecuted for bullying and harassment.
Awesome. Thank you for that answer. Is there any other questions that people want to go ahead and ask at this time?
May I just also, which I felt to say, in terms of when I talked about contractors, one of the key things also that we're still seeing is that because a lot of your work is defined as high-risk work, where you work above 2 meters, right? One of the key issues that we're still finding is the lack of understanding around the provision of safe work method statement. Under the law, if you are working above 2 meters or that the work is high-risk work, you must prepare a safe work method statement. If you don't, you are in breach of the law. So there is no defense, right, for that. And we've run a number of, well, we didn't run a defense on that, but we had to enter an early plea because there is no defense, because the law around that is absolute, because the regulation says that you must develop a swim. So I thought I'd just put it out there.
Thank you, Louisa. I don't think we have any other questions, but but like Naveen and Dane said, you guys can reach out to them if you have any further questions, or
Alright.
Louisa as well. Yeah,
There's another one on there, which we
I don't think so. Oh, is there? Did I miss one? Oh, I did miss it. I'm
a couple
sorry.
there. So Louisa, someone's asked in further to what you've just mentioned, could you clarify the responsibility on a site between the head contractor and the subcontractor, given the control of the head contractor?
Yeah, very interesting question. I'm glad someone asked that. So in a construction type environment, there will always be a number of people that would have management or control of the workplace. So effectively, the head contractor will have the ultimate management and control of the site, okay? But you as an employer will have specific control, but only to the extent where you operate, right? That is the extent of the control you exercise. But if you are given direction by the head contractor, that head contractor has also exercised control over your work. So what I would recommend is that when you're negotiating your contract, you have to be clear who will have ultimate control of the workplace. And typically it would be the head contractor, and the employer, i.e. A NECA member, would only have that control over that workplace that they operate under.
Thanks, Louisa. So there was one more as well. Does the right to, and we'll open this up to Dane or Naveen as well, does the right to disconnect mean an employer can't contact an employee, like via email or SMS, under the expectation that the email can be responded to when the employee is back on duty? Or can they just not make contact unless it's deemed reasonable?
Yes, I'm happy to take that one. So in under those circumstances, it's perfectly permissible to send an email to an employee outside of hours. It's still, there's no prohibition in attempting to contact. The only issue would be if the employee didn't respond to your email, so that you sent at 7 p.m, that you then went the next morning and say, hey, I expected to that, this is a warning or something like that. So you can still more than permitted to contact an employee via email. And if your expectation is, well, I don't expect you to respond to this within business hours, that's perfectly fine. You're still able to send that. It would only be if you then sought to discipline the employee for not replying to that email. So perfectly permitted to still send an email with the expectation that it be responded to during business hours.
I think that's all of them.
Yeah, okay, great. All right, well, thank you so much for joining us today, guys. We really appreciated hearing your insights, and I think Naveen's having technical difficulties, so he had to hop off, but we really appreciate it. And then I will be sending out the recording of this to anyone that's registered, and then you're free to share it to anyone else that you think would find this resourceful. So thank you, everyone, and have a great day.
Thanks, everyone.
Thanks, guys. Bye-bye.